My name is Ami Umairah binti Sinurai and my matrix number is 076723.
Assalamualaikum warahmatullahi wabarakatuh. My name is Mirwana binti Mokhtar and my matric number is 076610.
Hello, my name is Nurada Emeline binti Nur Effendi and my matrix number is 078175.
My name is Nurzaira binti Kamal. My matric number is 077179.
Hi, my name is Nurul Ainiana binti Muhammad Dinukaiwi with the matric number of 078294.
My name is Nurul Farhana binti Baharudin with matric number 077772.
Hi, I am Kurata binti Muhammad with the matric number 078633.
Hi, my name is Soha binti Muhammad Sofian, matric number 077341.
So for this group assignment, our team drafted a comprehensive partnership agreement for the Ophelia & Co., which is an upscale cafe located in Bung Badak, Kuala Terengganu. The cafe focuses on offering artisan coffee, premium teas, pastries, and curated light cuisine with the aim of providing customers a refined and elegant dining experience. The main purpose of drafting this partnership agreement is to formally regulate the legal relationship between the partners involved in the business. As partnerships are governed by both statutory law and mutual agreement, it is important for the partners to clearly understand their respective rights, duties, liabilities, and expectations from the beginning. So through this agreement, we sought to minimize potential misunderstandings and disputes by clearly setting out key operational and legal matters. These include the nature and scope of the business, the capital contributions made by each partner, the management and decision-making structure, the sharing of profits and losses, as well as procedures for dispute resolution, admission or withdrawal of partners, and eventual dissolution of the partnership. In drafting the agreement, our group ensured that the clauses are aligned with the Partnership Act 1961 while also taking into account the practical realities of operating a cafe business. This includes maintaining continuity of operations, protecting the goodwill of the business, and also ensuring fairness among the partners. So overall, the partnership agreement serves as a legal framework that balances statutory compliance with commercial practicality. It provides clarity and certainty for all partners, supports effective business management, and also helps to safeguard the long-term sustainability of the Ophelia & Co.
So, in my part, I'll be talking about the explanation of the key clause, and one of the clause is dissolution by notice. So, the purpose of this clause is to provide a clear procedures for dissolving a partnership at will, and to allow any partners to exit the partnership lawfully and also fairly, and to prevent sudden or informal dissolution that may harm other partners or also third parties, and to ensure sufficient time is given for preparation and also winding up of the partnership affairs. And the legal significance of this clause is to determine the exact date of the dissolution of the partnership, clarifies when partnership rights, duties, and authority change, and limits partners' authority to bind the firm after the dissolution. Reduce dispute regarding liability for debts and also transactions entered near the dissolution period, and also written notice serve as a legal evidence of intention to dissolve. And how it aligns with Partnership Act 1961, but it consistent with Section 34, Subsection 1C, where a partnership at will may be dissolved by notice from any partner, and reflects Section 34, Subsection 2, where dissolution takes effect on the date stated in the notice, or if no date is stated, on the date the notice is communicated, and ensure that the clause is statutorily valid and enforceable. And why it was drafted in a chosen manner? Because written notice requirement ensures certainty and proof, and 1 month notice period protects the interests of all partners, and also clear rules and effective date avoid legal ambiguity. Next, I will pass to the next presenter.
So I'll be explaining further of the key clauses in this part, where I was choosing clause 4 of the management and governance structure. So basically, what are the purpose of this clause? The primary goal of this clause was to prevent founder friction between partners that may appear during the business. The clause also acts as a prenuptial agreement for business, where it established a clear hierarchy of power to decide everything for the business. The clause was also upheld to reduce operational risks that could harm the business, and it also ensures accountability and transparency towards all partners. What are the legal significance of this clause? Firstly, the clause acts as the legal blueprint that helps the functions of the partnership internally. It acts as a shield against apparent authority, and also defines the operational structure of the partnership, and highlights the rights and responsibility of each partner. How does this clause align with the Partnership Act 1961? Firstly, the clause aligns with section 26 subsection E and H, where the clause acknowledges every partner to take part in the management of the business, and any differences that arise may be decided by a majority of the partners. It also highlights the flexibility of the voting threshold, where we raise the votes to 75% to constitute the business. Okay, why the clause was drafted in the chosen manner? Firstly, the agreement favors stability, where in clause 4.2.1, clearly giving everyone one vote shows that the draft was built to foster a collaborative partnership. Secondly, this agreement was to protect the intellectual property of the cafe, where ideas and improvements are necessary, but if it's not convincing enough for everyone, it is not as supported as it is. And lastly, the agreement was structured especially in clause 4.3.1 to prevent management fatigue, where the clause highlights only 3 main meetings on different time to supervise every matter in the business. So that's it from me. Thank you.
Moving on to the last key clause that I will be explaining, which is clause 613, which is the liability of incoming partners. So first, the purpose of this clause is to protect newly admitted partners from liability for debts and obligations incurred by the partnership before the admission. A new partner should not be financially burdened by past decisions or transactions over which they had no control of. This clause also encourages potential partners to join the firm by providing certainty and fairness regarding their financial exposure. At the same time, it preserves flexibility by allowing the partners to agree otherwise where necessary. This clause is legally significant because it clearly allocates risk between existing and incoming partners. Without such a provision, disputes may arise as to whether a new partner is responsible for pre-existing debts. By expressly stating that liability does not attach unless agreed, the clause protects the incoming partner and ensures that creditors and partners understand the limits of liability. The inclusion of a requirement for a novation or separate agreement further strengthens legal certainty by ensuring that any assumption of liability is enforceable and consensual. This clause clearly aligns with Section 19 Clause 1 of the Partnership Act 1961, which provides that a person admitted as a partner into an existing firm is not liable to creditors of the firm for anything done before they become a partner, unless there is an agreement to the contrary. The clause reflects this statutory position while also recognizing that liability may be assumed through agreement, provided it complies with legal requirements such as novation. Thus, the clause reinforces and clarifies the statutory protection afforded to incoming partner. Why does the clause was drafted in the chosen manner? This is to ensure clarity, fairness, and legal certainty. By expressly stating the default rule under the Partnership Act and specifying the only exception, namely a novation or written agreement, the clause minimizes ambiguity and prevents unintended liability. This drafting approach demonstrates prudent risk management, protects incoming partners, and ensures that any deviation from the statutory position is deliberate, documented, and legally effective. It also reflects a commercially practical approach suitable for a growing partnership such as the Ophelia and Co.
Now, as for the challenges encountered during the course of this project, we faced several challenges. First, differences in opinions has arose, particularly in decision making, as not all group members initially agree on certain choices. This has required constructive discussions and compromise to reach a consensus decisions against certain choices. Secondly, time management was also a major challenge between us. There was an adverse weather conditions in Terengganu last December has limited our ability to meet face-to-face, has resulted in most discussion and being conducted online instead. Finally, coordinating schedules amongst group members was also challenging due to the differing academic commitments among us, which also require flexibility and effective communication to ensure this project progress smoothly.
Explain the lesson I have discovered during this drafting progress. So there are 3 points, which is the first point. This partnership highlight the concept of holding out under Section 16 of the Partnership Act 1961. Even though Ophelia is only a nominal partner and does not manage the cafe, she is still liable to the third parties because the business operates under her name, which gives the impression that she is a partner. Second, all active partners are agents of the firm and are jointly and severally liable. This means any one partner can be held personally responsible of the cafe debt even if the issue is outside their specific role. Lastly, this partnership is a partnership at will since no fixed duration is stated. As a result, any partner may dissolve the partnership by giving notice, which provides flexibility but also creates instability for a long-term business like cafe.
To drafting partnership agreement, we learned that effective teamwork is essential to produce a clear and legally sound document, and constant communication is required in drafting the agreement in order to ensure consistency for all the clauses, since even small difference in wording could affect legal meaning. We also learned the importance of dividing roles based on individual strengths for each clauses, as it would improve efficiency and share the same and equal responsibilities altogether. We reviewed and refined each other's work to ensure coherence in the partnership agreement. This experience has taught us that successful legal teamwork depends on communication, accountability, and mutual respect, especially when working towards a shared professional outcome.
Okay, so thank you. Now moving on to our good reflection, which is the improvements for future drafting exercises. First is the consistency in format. So we have observed that some members use different formats and styles of writings in their drafts. This caused inconsistency throughout. So we suggest to establish a shared guideline and template at the start so all the drafts will follow the same format. Second is the roles and communication. We have observed that miscommunication has led to confusion of what was to be included within the drafting. Therefore, we suggest to actually assign a much clearer roles and maintain regular check-ins to clarify expectations and improve coordination. Third is creativity and idea development. So we have observed that the drafts were sometimes a bit basic and safe, alike to existing drafts available on the internet with few innovative ideas. Therefore, we suggest to encourage brainstorming sessions to explore creative approaches. And with that, thank you.